in your deliberations. When you're done, you can keep those, leave them in the jury room, discard them, whatever you want to do. When you
Ladies and gentlemen, there's some other stuff in this bill I would like you to disregard too. One of the text messages that we talked about, she told you, and this is interesting, that in the text messages there's no indication that you broke up with her. Read these yourself, there's plenty of indication. She makes statements in there, how can you walk away from me like this? How can you leave me? After all we've been through, are you going to just end it like that? And those are in that time frame leading up to when she runs him down. This Bella is wrong when she says that there's no indication that he broke up with her in there. You can see it in this defendant's own words. That's what's on her mind. She also wants you to disregard the threats that this defendant made. We're going to go through those in just a minute. Escalating threats in the text message. This Bella says Eric didn't take her seriously. Eric did not take her seriously enough, or the threats that she made. And you're going to get to see what those threats are on PowerPoint. They're directly out of her text messages to him. Ms. Bella would like you to disregard that as well, I'm sure. Ladies and gentlemen, all of the evidence in this case, it shows the cases about jealousy, fury, and refusal. This defendant's jealousy about Kendra Maddox, jealousy about the fact that Eric wouldn't leave his baby mama or wife or her fury at being second, at coming up second time and time again, when she couldn't pull him away from Kendra Maddox. She couldn't get him away from the mother of his children, and she was angry about that. You saw that last text message that she sends him 4.5 hours before she kills him, finds him at his baby mama's house. And then her refusal to let him walk away and then run away from her. And that's what led her to murder him. Murder has three ingredients that we talked about. You have the intent to cause serious bodily injury, and you each told me in jury selection, Ms. Bella wants to talk about intent to kill during her closing, but you know what the law is. The law is that it's intent to cause serious bodily injury. And you each gave me your commitment, your solemn oath, that if I prove the case beyond reasonable doubt, and you believe that the defendant had the intent to cause serious bodily injury, but you weren't sure about intent to kill, that you can still return a verdict of guilty in murder. I am holding you to your word now. We have proven when you run somebody down with a car, you intend to hurt them really badly. You intend to cause serious bodily injury. Second element, an act clearly dangerous to human life. And third, it causes the death of the individual. First, about intent to cause serious bodily injury, I want to clarify something. We're talking about intent, not premeditation. Some murders are premeditated. Some people plan their murders months in advance of the murder. They meticulously plan them. They order poison. Who knows what they do. Other crimes, other murders happen quickly. Intent is something that can be formed in a second. And one illustration I always like to use about this, I intend at the end of the day to drive home to my house. And I drive on Cal, exit Barnett Road. But as I pass Sonic, I think, gee, I'd like a Route 44 for happy hour, so I pull into Sonic. I formed the intent to pull into Sonic that quickly, just like when she pulled into that lot when she formed that intent. My intent is formed quickly. It was not my premeditation to stop at Sonic. My premeditation, if you'd asked me about it, I was going to go home that day. But intent can be formed in a second, and that's what happened there. So don't get confused with intent and premeditation. No one is saying this was a premeditated crime. She may not have set out to kill him that day, but you're going to see how her thoughts were moving in that direction. And she had her opportunity. He tried to walk away from her, and then he was running away from her. It was escalating, and she decided to run him down, and that's when she had that intent to cause serious bodily injury. Informed intent in a second. Let's look at her intent to cause serious bodily injury. Jury selection, we talked about how you can see someone's intent from their words, from their actions, and from their course of conduct. Those are all things that we talked about that are components. We don't have anything to see in somebody's brain, so we have to rely on their words. I submit to you, these messages give a really clear indication of what was going on in that relationship and what was in her mind. So you have words, actions, course of conduct. Let's look at the words first. Let's look at the words before. The words before this happened. We've seen some of the ones that talked about her obsession with Kimba and her anger and her words that day. But I'm going to look at a few more of these messages because I think they're important. You know, I think this is important, not that I think she ran him down for the money, but I think it explains why she's thinking about taking the money off of him. March 19th, after he's indicated, according to her text messages, that he's done with her, I want all the money I dished out to you besides the 15, it's $15, 1,500. The food money, the minute card money, I think you owe me about 50. That's March 19th, so she is thinking about money. I'm not saying she ran him down for the money, but I think that's why it was in her mind when he's gasping for air and she takes the money off of him. She had it in her mind that he owed her some money. And you also heard the evidence that he didn't buy her lunch at Stanley's, and she told the detective she was mad about that, so she had the money in her mind. And then we're going to talk about her threats. The defendant's threats to Eric show her intent. Eric did not take her threats seriously enough. That's why I think he didn't call for help. He didn't really think she would run him down. Yeah, sure, there were people in the neighborhood that he could have run over to, but he didn't take her seriously. He did not take her threat seriously. You're going to see that in one of these exchanges. These are all admitted into evidence. Her words. March 23rd. Okay, don't do this. I know where you at, and you know what I'm capable of. Her words to him a month before she runs him down. March 30th. I shouldn't have to beg your ass, but keep it up. Your time is limited. April 5th. Your ass going to end up on a milk carton. Keep playing with me. We all know what the phrase, you're going to end up on a milk carton means. We know what ends up on milk cartons. Missing people end up on milk cartons. Your ass going to end up on a milk carton. Keep playing with me. He's an independent witness. And then you have the action at the scene that she takes $128 off of him. Listen to the statement. She says in there that he was gasping for air, and she's taking the money off of him. Gasping for air, taking the money off. It doesn't matter if Lee Mitchell was saying get the money off like they want you to believe. Who knows? He's gasping for air, and she's cleaning his back pockets out of money. That shows her mental state. Oh, sure, she's hysterical by the time everybody arrives, but her first thought is get the money off of him. How on earth do you swear that, ladies and gentlemen? Is there anybody that if you accidentally hit somebody and somebody else comes up with a scene that's like get the money off of him, you're going to go, oh, okay, I'll get the money off of him. That's ridiculous. It's preposterous. It's what Miss Bella wants you to believe. The more he rejected her that day, the angrier she got. She takes one shot at him, doesn't get him. He rejects her more. He runs away from her, and that's when she tags him. Quick thing about the speed. Dr. Krause said anywhere from 5 to 25 miles per hour. I submit to you, first off, Ms. Bella talks about dirt and dust being thrown out. You saw the pictures. Her car is stuck in mud. There's been a lot of rain, so that doesn't make much sense. Secondly, whatever speed she was going at was enough to run him down and to crush him with her vehicle. You heard Dr. Krause's testimony that 10 miles per hour would be what a human runs a 6-minute mile. 20 miles per hour would be a 3-minute mile. There's nobody that can run a 3-minute mile in this room or probably on this planet. So 20 miles per hour is far faster than any human can run at. Dr. Krause said that at 15 miles per hour or faster, you would easily run down anybody on foot. So the speed, don't be misled by that. She was going fast enough in that field to run him down and to crush him into her car. He doesn't go up on the hood. That's evidence he wasn't running toward her. And speed is a relative thing. We think of speed as fast in vehicles, 70, 80, 90 miles per hour. When you're talking about someone on foot in a field, 20 miles per hour, 15 miles per hour, 25 miles per hour, whatever it was, nobody can tell you for sure. That's fast enough to kill him. Manslaughter and criminally negligent homicide, I want to talk about those briefly. Some crimes are intentional, and then some crimes are accidental. There are such things as accidental crimes. You have the definitions in there. Manslaughter and criminally negligent homicide are crimes involving accidents. We're talking about the person that runs the lot in the afternoon going 60 miles per hour, blows through the line of the intersection and kills somebody. That would be manslaughter. It's an accidental crime. You don't intend to kill somebody. It's an accident. Those are crimes involving accidents. If it wasn't an accident, it cannot be manslaughter or criminally negligent homicide, ladies and gentlemen. If it's not an accident, it's not that. We have Officer Lamont's testimony that it's not an accident. He told you he saw no evasive maneuvers. He saw no swerving. He's the expert. He sees no swerving. She doesn't stop once she starts crunching him under her car. There's no evidence from Officer Lamont that it's an accident, that he was running toward her, any of that. But not only did Officer Lamont not testify that it was an accident, you have her own words. Watch your hand gestures.
It wasn't an accident. It wasn't. I ran right into. I ran right into him. It wasn't an accident.
You saw her hand gestures, and we talked in jury selection that sometimes people's nonverbal cues tell the whole story. It wasn't an accident. I ran right into him. She is acting it out. She's seeing it as it happens in her mind, and she's non-verbally telling the officers what happened. Her words, ladies and gentlemen, it was not an accident. If you accidentally hit somebody, if you accidentally killed somebody, is there anything that in an hour interview room could get you to say that it was murder? That makes no sense at all. Then you add in the force of conduct, the threats, all of that stuff, the fact that she tried to hit him before. We have 2 independent witnesses that saw her try to hit him before. This is not an accident. She intended to do it. And you can't hit somebody with a vehicle. First off, hitting somebody with a vehicle is an absolutely dangerous human life. No question about that. Anybody with children knows that. We start off probably at age 5 or earlier knowing how dangerous vehicles are, how dangerous they are. Some parents, that is the most severe punishment that they dish out to their kids if they catch them playing in the street. We all know, she had to know how dangerous vehicles are. That's common knowledge. Hitting someone with your vehicle at any speed, unsafe at any speed, is an act clearly dangerous to human life. We also talked about how some actions show the intent themselves, like dropping a cinder block off of an overpass that hits a vehicle, that shows your intent to cause serious bodily injury. Running someone down with a 2,800-pound vehicle shows her intent. That action itself shows her intent. And then she tells you herself that it wasn't an accident. And then cause of death, you heard Dr. Krause's testimony. He was crushed to death by a motor vehicle. The manner of death was homicide.
5 minutes.
So, ladies and gentlemen, I suggest to you that you should reject the lesser included of manslaughter, criminally negligent homicide, because it was not an accident. She intended to cause him serious bodily injury. She may have just formed that intent when he runs away from her there, because intent can be formed in a second. But when she accelerates as she enters the lot, she tests her words in that interview were that she was not coasting when she was going over the bill, that she accelerated, and that matches what Pamela Strong saw down here of her accelerating. When she accelerates, when she runs him down, that shows her intent to cause serious bodily injury. You can't hit somebody with a car and not intend to cause them serious bodily injury. Ladies and gentlemen, when I ask each of you that if I prove murder beyond a reasonable doubt, intent to cause serious bodily injury, would you be able to return the verdict guilty? Could you do that? And you all told me that you could. I have proven the case beyond a reasonable doubt. Manslaughter and criminally negligent homicide are lesser included. If you believe I proved the murder case beyond a reasonable doubt, which I have, but then you enter into a lesser included, a compromised verdict, for whatever reason, there's a couple of problems with that. First off, you're violating your oath, the oath that you took to return the verdict of guilty to murder if you believe I proved it beyond a reasonable doubt. Secondly, it erodes the sense of our justice system when there are these incomplete, compromised verdicts. When I prove murder beyond a reasonable doubt, but a jury does not have the courage to convict someone of what they did, it erodes the safety of all of us and the confidence in our criminal justice system. Third, you all told me that you believe in equal justice under the law for male defendants and for female defendants. I think you've seen through the course of this trial why that's an important commitment that I ask of each of you. You saw the interview and all the tears, all the crying, all the Miss Bella's favorite word, which is on the witnesses, was that Miss Wetzel was hysterical. Over and over and over, tears, crying, hysteria. You heard from Detective Love, it's a common thing with female defendants, females to cry a lot in interview rooms to try to garner sympathy. You all told me that you could disregard that and you could base your verdict solely on the evidence in the case, that you could convict a female defendant of murder. I've proven the elements beyond a reasonable doubt. I've proven the case, and now I need you to follow through on your commitment to me and give her equal justice under the law. She committed murder that day, and I would ask you to convict her of murder. You know, we talked about 3 rules in this case. If someone wants to leave a relationship, they should be able to do so without facing death or violence. Eric was walking away from her. He was running away from her. She had no right to bring him down because he did that. Dating disputes should be kept private. If someone is unhappy with the actions of the person they're dating, they should not endanger the community through a violent public outburst. Over right at a mile, violent public outburst. Every witness, after she leaves her house, places her as the aggressor with Eric doing nothing. Through our community, violent public outbursts. That's the type of thing that endangers our community. Third, that no matter how angry, upset, or jealous, and you saw her text messages, you saw how upset, angry, and jealous she was, no one has the right to subject their children to a violent public outburst to endanger their kids. You heard the testimony of her throwing her kids in the car, and then she runs him down with her kids right there. Not only did she break those common rules that we all accept, she broke the law. How many times have you heard someone, you hear about someone committing a violent act, taking another life, a human life, and Eric Powell was a human being. He may have done some things that we don't approve of. It's up to God now to judge him thanks to her actions. That's not our job. He's a human life, and he's protected under the law. We hear about someone committing violent acts and taking human life, and we say, why doesn't someone do something about it? I submit to you that Detective Blood and the good men and women of the Wichita Falls Police Department did their job on the scene. They collected the evidence. They took the interview. They have done something. Mr. Suter and I, and Mr. Martinez, other members of the DA's office, we have tried to do our job to you, to give you the full picture, to give you the witnesses, to give you the text messages, all of the evidence, to show what she did that day, to show what her intent was. Now, ladies and gentlemen, it is in your hands. It is your duty. It is your responsibility. It is up to you. And it's incumbent upon you to convict her of what she did, which she formed that intent and she ran him down in that field. She committed murder that day by committing an act of really dangerous to human life with the intent to cause serious bodily injury. It is up to you to return a verdict of guilty, and I ask you to do that. And when you tell her she's guilty of murder, ladies and gentlemen, you're not going to be telling her anything she doesn't already know.
Everyone remain seated until court's adjourned. Ladies and gentlemen of the jury, I'll send you to the jury room now to consider your verdict. Again, I'll deliver the charge, the original charge, and the exhibits to you. There's pencil and paper in the jury room as a reminder. If you have a question or anything you need to convey to the court, your presiding juror needs to write that out, sign it, and then knock on the door. I'll have a bailiff at the door. Lunch today is probably going to be somewhere around 1 o'clock, just so you'll know that. When you're ready to return your verdict also, if you'll knock on the door, I'll have the bailiff return you back into court with that verdict. With those instructions, the jury is excused. Again, everyone remains seated. The defendant's excused.